Hi there, I'm Simon Bennett from OMB Solicitors and welcome back to the OMB Law Board. Today I've got Erlinda Nunn from our property law team here with me. Erlinda, welcome back.
Thanks for having me, Simon.
So Erlinda, with the growing pressure of housing affordability, one thing we're seeing become more and more common is co-ownership models, granny flats, shared use of properties. And today you and I are going to talk about some of the key pitfalls on co-ownership and what to watch out for.
That's right. At the moment, I'm seeing a lot of people with inquiries about what happens when a co-ownership agreement goes wrong. And 9 times out of 10, there won't actually be an agreement in place.
Okay, well, that's a good starting point. Maybe we should dial it right back to the beginning. What are the different types of ownership for property?
So where there's 2 or more owners, people can own the property as either joint tenants or tenants in common. So the difference between that is if you and I were to hold the property as joint tenants, we each have an equal 50-50 share in the property. And if I were to pass away before you, my share automatically gets transferred to you. On the other hand, if we were to own the property as tenants in common, we can own it as 50-50 equal, or we can have uneven shares such as 1-99, 60-40, 70-30. And sometimes those shares may be dependent on our contributions to the property. And then upon death of a tenant in common, that share is usually dealt with in accordance with that person's estate.
Okay, so for the purpose of this co-ownership, we're going to talk about tenants in common. So where you're entitled to deal with your percentage share however you see fit, and there may be unequal shares, and that the parties who own the shares may not be necessarily in a relationship. It could be a joint investment, or it could be, what we're seeing a lot of, the children owning part of the land and then the parents owning a separate part, but legally they all own the whole property together, but just in differing shares.
That's right. And another way that in those sorts of arrangements where people can own the property together, they might hold the property as joint tenants inter se. So, for example, a couple purchasing might hold the property as joint tenants. And if they've purchased the property with, say, their parents, the parents may be tenants in common with the children.
That's getting quite confusing, but I think I understand the concept. So that I could own a 50% share together with my wife as joint tenants.
Correct.
And then we could own the other 50% with the other party as tenants in common.
That's right.
So let's talk about this tenants in common agreement, because I really want to drill down and understand what we're doing with it and how it's useful. So maybe you could lead us off through that.
Yeah, of course. So at the moment, we're seeing arrangements where people have purchased a property together. And now, for example, one couple may want to exit that agreement. Without an agreement in place, there isn't really a lot of scope of how we deal with that person's share. Generally, your options are to perhaps refinance if you do have a mortgage on the property, and then repay that buyer out so that the other co-owners become the registered owners of the property, or they may have to sell the property altogether. And issues can arise there if some of the other co-owners don't agree to that sale. Then perhaps they might have to bring an application to the court to force a sale.
So what else do these tenants in common agreements generally deal with? Do they deal with expenditure and who pays for what, and what sort of stuff do we
So
see?
in these types of agreements, we would usually include things like what the parties' contributions were when they purchased the property. We'd include things about who pays for what, so outgoings of the property, including rates, water, insurance. What happens if a co-owner tips in more money to make improvements, or who deals with the maintenance of the property. And we would also include provisions about exit strategies, how we deal with who gets paid what, how we exit, what the agreement is there.
And can those exit strategies include either pre-agreed amounts or methodologies for creating a value?
Correct. So generally, we would include some form of mechanism in the agreement, which may, if the parties can agree on a fixed amount, that could be something that's worked into the agreement, or if we don't know what the value of the property will be in the future, it might be based on a market appraisal or evaluation.
Yeah. And this takes away the uncertainty and the disputes that we're seeing.
It certainly does. Having things documented and having clear expectations when you enter into these kinds of arrangements prevents heartache in the long run.
Yeah. I always feel like having the most difficult conversations when you're all getting into it, because you're all friendly, everyone's happy, have the really difficult conversations then. What's going to happen if this? How do I get out of it if you don't want to be involved, et cetera, et cetera? Because obviously once you've got the dispute later on, probably you're not talking too well, communicating too well at that point in time.
No, that's right. And unfortunately, we don't have a crystal ball. We don't know what the future holds. While a lot of these parties enter into these agreements thinking it's a great idea financially, when it comes down the line and someone wants to exit, that's where these disputes can arise. And this is where things can get a bit messy when we don't have clear expectations or agreements or know how we are to exit.
So the other area of this joint ownership that we see a bit is this commonly referred to as granny flats. So that you've got, one family group living in a main house and then there's a second dwelling or a granny flat. Can you also deal with that arrangement under these type of agreements?
You certainly can. We've even seen specific granny flat agreements in place. With those types of agreements as well, depending on, say, if there's someone's parents living in the granny flat, if they're a little bit older and retired, there may be some other issues with pensions and things like that may need to be considered when giving that advice and drafting those agreements.
And at OMB Property, I know certainly when we get involved in this, we're also talking to the clients about their estate because that relates to this sort of arrangement as well.
It certainly does. With these types of arrangements, we always recommend that clients speak to our estate planning team as well because it can become intertwined.
Wow. Okay. So there's heaps in that. I think it's vital that you get good advice from an expert who knows what they're talking about because as these blended living arrangements are required through cost of living and housing affordability issues, these type of joint ownership arrangements are going to become more and more common. The key takeaway is get it in writing, have the conversations while you're still friendly, and get an agreement done, which hopefully you don't need to look at in the future. Erlinda, thanks for coming in today and talking to us about this really informative topic.
Thanks, Simon.
And if you've got any questions on joint ownership of property or property ownership generally, please drop us a comment below and we'll do our best to cover it in one of our next sessions.